We're convening in a pre-hearing conference in SOAH docket number 529-13-0997, Antoine Dental Center petitioner versus Texas Health and Human Services Commission Office of Inspector General respondent. Today is May 21st, 2013, and it is 1:30 p.m. We are in the William P. Clements Building in Austin, Texas, and the proceeding is being recorded. My name is Catherine Egan. I'm one of the administrative law judges assigned to preside over this matter, and with me is
Howard Seitzman, the other presiding ALJ, or co-presiding ALJ.
Before we proceed any further, let me go ahead and take appearances for the record, beginning with Antoine Dental Center.
Yes, Ron. For Antoine Dental Center.
Oh, get the box up. Go ahead.
Yes, Ron. Tony Canales, and I'll let everybody introduce themselves.
And if you're new, could you spell your, well, you're not new, but if you're new, please spell your name.
Tom Watkins from Brown McCarroll.
Philip Hilder, Hilder.
James Riddick, Hilder Associates, that's Rytting.
William Graham, Graham, Hilder Associates.
And you're going to need to speak up.
William Graham, Graham.
Thank you.
Thank you, ma'am.
Beza Nazari, Behcade, Nazari, Nazari.
Thank you, Mr. Mazzone. Go ahead.
Dan Hargrove, Hargrove.
Good afternoon, judges. Raymond Winter with the Attorney General's Office, WINTER.
Good afternoon. My name is Gavin Carode. First name is Ketan. Last name is Kharove.
I'm Bill Moriarty for OIG.
I'm Caitlin Silhan, Caitlyn, and Silhan, Silhan.
Mark Einfeld, EINFALT.
John Medlock, MED,
Margaret Moore, OAG.
Enrique Varela, VARELA, OIG.
Mr. Moore and Mr. Winter decided they just couldn't get enough of us, and so they came back. And so much for special appearances, huh?
So much.
All right, let me just remind the parties that under our rule, there needs to be an attorney in charge, and at the current time, it's Mr. Hargrove on behalf of the respondent and Mr. Canales on behalf of the petitioner. If you want to circulate copies of whatever's issued from the State Office of Administrative Hearings or what's received from the other parties, you'll have to make arrangements on how you want to proceed on that. But each party gets an attorney in charge, and that's who our service list goes to.
Understood, Your Honor.
Although I will say that if something addresses a particular attorney who's not the designated attorney, such as a withdrawal of counselors, we will send a courtesy copy to that attorney, as we did with Mr. Hargrove and Mr. Moriarty.
Okay. We have a number of motions that have been filed since Friday, and we've got a hearing that begins next week, the first business day of next week. So we're going to try to take these in some kind of order. My preference is to begin with the motion to start Mr. Houston as a witness.
Actually, I'd prefer to take care of a couple of procedural matters.
All right, let's go ahead and do that then.
If we can, court reporter for the hearing. Have y'all made arrangements for that?
I believe we have, Your Honor.
Okay. And then to the extent that we need to take up costs or related to the court reporter or whatever, if that's an issue, we can take that up at the conclusion of the hearing.
Okay.
Judge, can I do one thing? Can I switch your names around?
Yeah, go ahead.
It's a little distracting. I keep going to the one side, the other side. Let me see. Forgive me. There we are. Now we're in good shape.
Well, there's so much for double jeopardy, huh? Actually, I will confess that one time another judge who's since retired, but he and I ended up having to trade cases because of a situation that came up and something that needed to be handled. And somebody didn't like the ruling that I didn't make that he made in my place and wrote an 8-page complaint and used my name about 25 times. Okay, so I'm glad you got us separated. Yeah, okay. All right, so the court reporter issue then is not an issue.
The other issue is there's an order that directs that all exhibits are to be hole punched and put in a 3-ring binder. It's order numbers 1 and 2. Some of the exhibits have come in not in binders, and the parties need to make sure that at the time of hearing that those are in binders. I believe it's the respondent who filed theirs without putting them in binders, but if you'll notify the docketing when you want to come down and hole punch them and put them in binders, we will make sure that they're out of our office and over at docketing.
We'll take care of that, Judge.
And then just another thing, just to kind of give you a heads up, and we'll do it, and we can actually do it off the record, but just for calendaring, after we've gone through all our rulings and taken care of everything else, what we would like to do is sit down and kind of work out the order of your witnesses and how long you anticipate the witnesses. And I realize it's sometimes difficult to identify exactly how long the direct is or exactly how long the cross is. So it's not for the purpose of saying you said 30 minutes and you're limited to 30 minutes, but it's so we don't have witnesses sitting around and we have an idea of if we work late one day, we'll be more likely to finish up. So
I call that the batting order. So after the hearing, we'll have a batting order?
Right, we'll sit down and we'll do that and get that. And that will also should facilitate you knowing who's going to be up in what order, so you can get your cross prepared, and to the extent that you've got different attorneys handling different witnesses, it should facilitate that. So we'll take that up at the conclusion. If somebody feels like they need to do it on the record, but it's a pretty informal discussion, so we can do that. Okay.
And I like at the end of each day to just clarify who's going to be arriving the next day, so that, again, everybody can be prepared to go forward and the attorneys know who is going to be cross-examining that witness, and they're sitting where they need to be sitting so they can do that job.
One other thing, and it may or may not be an issue, but in going through the Smile Center documents,
Yes.
I noticed that there's some photographs of individuals in there, and most everything was redacted. Somebody did a great amount of work. We're doing that. We'll take that up. I know there's an objection to those documents, and we'll figure out what's going to happen, but I just wanted to point out that if any of those documents come in for any reason, we may have to go back in, and you don't need to do it before the hearing, but what we'll need to do is, for the ones that do have photographs, we'll probably, if they're in, just substitute a corrected CD or something like that that has those redacted. It'd really just be for the record copy. I'm not so much worried about our copies because we can return them to you or have them destroyed, but just for the record copy.
We'll note that.
I also remind the parties, our rules require that when a motion is filed, a certificate of conference must accompany that motion. Occasionally, docketing will simply return it if that certificate of conference is not there. So please make sure to include that if you intend on filing any more motions, although I'm hopeful that this will be the last round of motions that we receive.
Okay.
All right.
Go ahead.
Let me just go through what we have, and then my preference is to start with the motion to strike Mr. Houston as a witness. But what I believe is still pending is that motion, the motions to strike portions of Dr. Orr, Dr. Evans' testimony, a motion in limine regarding Jack Stick, and a motion to strike Mr. McClendon, objections to petitioner's exhibit corresponding with the motion to strike Mr. Houston as a witness, and then the objections to petitioner's exhibits.
Correspondence.
I'm sorry, yes.
We just have one objection to P76, but we have, as my notes or our notes, but a number of objections to respondents' exhibits. Okay.
Yes, thank you.
Judge, we can take the P76 up at the same time as the motion to strike Mr. Houston.
Okay.
Then let's go ahead, and we have read all these motions, so please be brief. If we may have some questions, but at this time, I believe that is your motion?
That's correct, Your Honor.
Then go ahead.
Mr. Winter is going to be addressing the court.
All right, Mr. Winters?
Can I inquire, can we sit down while we have to?
No, you can sit down. No, thank you.
I've got a bad knee, that's all. I really have to get this.
No, because if you stand up, then you're further away from the mic, and those
Oh, okay.
mics don't have a lot of reach in
Fair,
terms of
fair.
the volume. So.
Our
Thank you.
But if you will pull a mic up next to you, thank you.
Judge, may I just ask a housekeeping question, and that is, I've never had the pleasure of appearing before two judges, 1, 3, 9 maybe, but never two. Is there a division of labor
Yes.
with the court here?
But not yet. We're not like the Supreme Court where we've divided it up yet, but we will either, we may divide it up before we actually, portions of it before we go to hearing, but certainly after the hearing, we divide up who's going to write what, or who has primary writing responsibility for certain issues is the way it works.
And during the hearing, we usually split the day. One judge makes rulings in the morning, and one judge makes them in the afternoon. So you're real clear on who you need to direct your objections to or your comments to.
And if there's a tie, we'll flip a coin.
That's right.
We'll use the coin of knowledge. It's 50-50 most of the time.
All right, Mr. Winters?
Good afternoon, Judges. Raymond Winter again with the Attorney General's Office. We have filed on behalf of OIG a motion to strike both the designation of Mr. Fred Houston as a witness in this case, as well as in the same instrument, a motion to strike Petitioner's Exhibit P76, which pertains to Mr. Houston, specifically the testimony that Mr. Houston gave, I believe in March, before the Texas Legislature House Committee on Public Health. This is a motion that OIG takes very, very seriously. It has far-reaching implications for the integrity and for the legitimacy of our legal system. And the reason for that is that Mr. Houston, as is pointed out in our motion and indeed in the designation filed by Antoine is a former OIG employee. But more than just being a former OIG employee, Mr. Houston was an OIG lawyer. He was counsel for the state, for OIG, the respondent in this matter, that brings this case, or at least the underlying investigation case against Antoine Dental. He held the last position as the director of sanctions at OIG, which is the very office that employs and manages the attorneys that bring these matters on behalf of OIG, the in-house lawyers. Anything that Mr. Houston could bring to this matter that is in any way remotely relevant to the proceedings before the judges is privileged. It must be pursuant to the authorities that we cited in the motion, and I take it that since Judge Egan said you've read it, you all have a copy. I've got extra copies.
We've got it.
We've got it.
But the authorities are plain. There is an irrebuttable presumption that when an attorney is counsel of record for a client, that attorney did participate in and did gain client confidences, and there is an irrebuttable presumption that attorney has knowledge of information that is protected under the attorney-client privilege. And it is clear from the affidavit of Mr. Wilson, who is the Inspector General and was the executive of the agency that employed Mr. Houston at the time he was there, that Mr. Houston participated in numerous strategic conferences discussing strategies, enforcement policies, priorities, and that all of those communications are, again, protected by the attorney-client privilege. They are also protected by the corporate product privilege. And we would add that under the disciplinary rules of professional conduct, Rule 1.05, Mr. Houston is precluded, even if those communications and confidences were not subject to a privilege, he is precluded from divulging those in a manner that is adverse to his former employer. The privilege belongs to OIG. It does not belong to Mr. Houston. He does not have the capacity, he does not have the capability to waive these privileges. I anticipate that one of the things that you're going to hear today from Mr. Canales or whoever argues this for Antoine Dental is that the cat's already out of the bag. These privileges have already been waived because Mr. Houston testified before the Texas Legislature back in March and no one raised an objection. But quite frankly, judges, that's a red herring. First of all, there was absolutely no notice to OIG that Mr. Houston was going to testify before the legislature that day, and certainly no notice of the substance of his comments. Second of all, there was absolutely no effort made by Mr. Houston or by anyone on Mr. Houston's behalf or on Antoine Dental's behalf to seek the consent of OIG, either for that testimony that occurred back in March or for any testimony that Antoine Dental hopes to elicit in this proceeding from Mr. Houston. Had such consent been requested, it would have been denied, would not have been granted. The affidavit of Mr. Wilson makes that plain. There has been no waiver of the attorney-client privilege by OIG, no request that it be waived, and certainly if that request had been made, it will be made, it will not be acted on, will not be granted. So the OIG stands by the privileges that it and it alone has the capacity to waive. It has not waived them. Mr. Houston does not have the capacity to waive those, despite the fact that he gave this testimony, which was quite frankly inappropriate under the disciplinary rules of professional conduct when he gave it, and it has no bearing on the proceeding before this case. To sum it up, judges, anything that Mr. Houston would testify to live in this proceeding is privileged. We do not waive the privileges, so we ask that you strike him as a witness in this case. With respect to Exhibit P76, we have 3 objections. We have a hearsay objection because we did not get the opportunity to cross-examine Mr. Houston during that testimony before the legislature. We have a relevancy objection because it appears that he has no knowledge of facts that are actually relevant to the specific facts of Antoine Dental. And thirdly, we have our privileges. We have the attorney-client privilege and the corporate product privilege, which go to the extent that anything Mr. Houston purports to attempt to testify to, either live or via this prior testimony, that implicates OIG enforcement strategies, priorities, interpretations, is absolutely protected by applicable privileges. The hearsay objection, by the way, with respect to the proffered exhibit, goes not only to the fact that we did not get the opportunity to cross-examine Mr. Houston when he gave that testimony, it also goes to the fact that that's not even a verbatim transcript of what he actually said that day. What the exhibit P76 is, to my understanding, is a transcript of anticipated remarks, and it's not an actual recording of what he actually did state that day. So in sum, there's absolutely nothing that he can say that's not privileged. We don't waive the privileges, and we ask that he be struck both as a witness and the P76, that our objections to that exhibit be sustained.
Surprise on Mr. Houston. I was there in the legislature. He appears voluntarily, files P74, I believe is my exhibit, with the clerk. And this happened, I believe, on March 19, 2013. Proceeds to read his statement and then answer a series of questions. To say the least, Judge, shocked. Wasn't expected to testify. The staff that was there for OIG, I believe I recall Mr. Stick was there. Some other personnel for OIG was there. The House member, or the chairman of the committee, invites Mr. Stick to respond to Mr. Houston's statement. I don't know why he did it, what his motive was, but he did it. I do not plan to inquire of Mr. Houston about general conduct, only what's within the statement. I attached the statement just to be able to limit myself to what my area of inquiry would be. I believe his area of inquiry, or what he talks about in his P76, is that he is generally speaking about a pattern of conduct that is being conducted by Mr. Jack Stick. Mr. Jack Stick will be a witness in this case. He's been designated as the first witness for the respondent. And this is totally contrary, or is an impeachment of what Mr. Stick has testified in the deposition. We believe that while Mr. Houston was a former officer and so forth, but that doesn't, he is not revealing anything of policy. I'm sorry, he's not revealing anything that should not come out publicly. It is not a privilege by the state to be able to say we are privileged because we can kind of conceal or cover fraud. We all know the exception about the attorney-client privilege doesn't apply to either criminal acts or fraud. The fraud part of the rule can be civil fraud, criminal fraud. If it's civil fraud in this particular case, it means basically it's somebody's deliberate intent to be able to testify contrary to what the policy is. In this particular case, these are serious charges. Now, I didn't encourage Mr. Houston to go forward. I didn't even know he was going to do it, but it's there. Now, what actions has the state taken, by the way, against Mr. Houston? Did they file a motion with the chairman of the committee, I believe this is Representative Raymond, to be able to strike his testimony? Have they taken any action against him? I don't think they have. I think the records bear on that. The question is whether or not Mr. Stick is going to be able to testify to things that I believe are totally contrary, that a fellow officer who's now going public with this, whether he should have gone public or not public, that's not beyond us. It's true. The cat is out of the bag. He has said it. And I don't think that the state's entitled to be able to use this statement as some kind of a shield and then go forward with a sword with Mr. Stick saying, we run a great shop, we've never done this, so forth. So I think I'm entitled to be able to show it. Now, is it unusual? You bet. Is it something that, well, I don't know if I will ever see it again for a long time, but in today's aura or today's thing about whistleblowers and people coming forward, I think it's admissible. It's admissible, by the way, for the purpose of impeachment. I don't plan to offer it, by the way, if Mr. Stick doesn't testify, I do not plan to offer this matter on the case in chief. It is, again, a rebuttal issue. Will he be able to rebut the statements that Mr. Stick, I've already taken Mr. Stick's deposition, I've inquired about these areas, and he denies them. So I've got here one officer saying it never happened. I've got another officer saying going public, it did happen. I think we're entitled to impeach. So it's got nothing to do, by the way, with the issue of privilege. I don't think there's a privilege of being able to conceal wrongdoing. And that's what they're trying to do. Trying to conceal wrongdoing by Mr. Stick. So I submit to the court that we're entitled to be able to subpoena him, call him to the stand, and inquire what he would have testified. And I've got the statement of what he would say. I don't plan to go outside that statement. I don't plan to inquire of anything else except, did you appear? Did you say the following things? They want to ask him why. That's their problem. I don't plan to ask him why he did it, but I like to be able to follow up the statements he made for the purpose of impeaching Mr. Stick.
Mr. Winter, do you want to respond before we ask our questions?
I would like to respond to this, thank you. A couple of points. First of all, it doesn't matter what Fred Houston did voluntarily. He could publish something in the New York Times or the Austin American Statesman or go on Oprah Winfrey. He doesn't have the capacity or the authority to waive these privileges. He's not the holder of the privileges. The OIG is. So it doesn't matter where Mr. Houston testified, when, or to what length. He cannot waive these privileges. And so that's the first issue. The second issue is it appears now that Antoine Dental only wishes to use Mr. Houston as some buttress for cross-examination of Mr. Stick. Of course, nothing in our motion has any bearing on whether or not Mr. Canales wants to cross-examine Mr. Stick when Mr. Stick testifies in this hearing. He's free to cross-examine him. He's just not free to use attorney-client privileged communications or testimony to aid in that cross-examination. There is no cross-examination exception to the attorney-client privilege. There is no obstruction of justice exception to the attorney-client privilege. He cites those things in his response that was filed yesterday without any supporting authorities. He invoked today the crime fraud exception. to the attorney-client privilege. The crime-fraud exception to the attorney-client privilege, judges, has not been properly invoked in this case. It is incumbent upon the party wishing to pierce the privilege to first make a prima facie showing of a fraud. There has been no such showing. I have authority supporting this if the judges would like me to provide those. But the single case on this is Granada Corporation versus the Honorable First Court of Appeals, Texas Supreme Court, 1992. It is incumbent again, if he wants to invoke the crime fraud as a basis of getting around applicable privileges, he's got to make a prima facie showing that a crime or a fraud has been committed. There has been no such showing today, absent a reckless allegation. And they can't do it. They can't get to it. The testimony that was given before the legislature, anything that Mr. Houston could possibly say in this proceeding next week is absolutely protected under the attorney-client privilege and the corporate privilege. We stand on those privileges. We don't waive them. We urge you to strike both the exhibit and the witness.
Your Honor, may I suggest something?
Just identify yourself for the record.
Tom Watkins from Brown McCarroll. 105 also has a part in it about truthfulness to a tribunal, incorporating 3.03, and I don't think that this court can tell whether or not, when Mr. Stick testifies, Mr. Houston may have to decide if his client has made an untruthful statement to a tribunal, and you should rule at that time as to whether or not the attorney-client privilege could be waived, because he has an affirmative obligation under both 3.03 and 1.05 to reveal to the tribunal if, in fact, his former client has made an untruthful statement and he needs to correct it. And so I'd suggest that you may rule on the attorney-client privilege generally, but we need to keep open the question of whether or not he has an affirmative duty under the rules to make a statement to correct what has been said by his former client.
You're not contending, Mr. Winter, that everything that Mr. Stick did, said, Mr. Houston did or said while he was at OIG is privileged, are you? In other words, if the question were, Mr. Houston, what hours did you work? What days of the week did you work? That's not privileged, is it?
I think that's a pretty innocuous question, Judge. I grant you that the answer to that question is not privileged, but bear in mind...
And we go on. Okay, I just need an answer to my question. All right, and the policies, the written policies of the department, they're not privileged, are they?
I think they are, Judge. I think those do.
Something in the Texas Register is privileged?
I'm not referring to those. I'm referring to enforcement policies.
I'm asking you that the stated policies of the institution, of the agency, those are not privileged, are they?
I think we have to be specific about which policies we're talking about.
If you state them, they're not privileged.
If they're disclosed to third parties, it's not a privilege.
You publish it in the Texas Register, if you publish it in a bulletin, if you introduce it as a policy at a proceeding, that this is the policy of the agency, there's no privilege to that, is there?
I certainly agree with you that matters published in the Texas Register are not privileged.
If Mr. Houston were asked the question of, at the time you were there, did the agency ever prosecute X type of case? That's a fact question. It's not, there's no issue of privilege, is there?
I think that is a fact question, Judge. That appears to be a far cry from what Mr. Houston was designated.
I'm just saying, you seem to take a blanket approach that anything that Mr. Houston could testify to was privileged simply because he worked there, and he worked there as a lawyer, and he happened to be, in the sanctions. But I guess we have to, what I'm wondering is, don't you have to wait and hear the question to know whether the question calls for something that's privileged or not privileged, and also make a determination as to whether the privilege has been waived by some other action? It could be the agency's action, because the agency may have made a statement in the proceeding as to what its policy was, either in this proceeding or some other proceeding. What I'm trying to say is, it's not just a blanket because somebody works at an agency as a lawyer that everything they did, said, heard, and uttered is privileged. It may or may not have been privileged, and the privilege may or may not have been waived by the agency in the course of some kind of action, either through publication. So the deliberative process, when you're developing a rule, there may be a deliberative process privilege. But when you publish the rule for comment in the Texas Register, or for final adoption in the Texas Register, there is no privilege as to what the rule says anymore, right?
I agree with that.
And the agency takes a position in response to comments and interprets the rule, makes an interpretation of the rule as they're adopting the rule and responding to comments, doesn't it? And so the deliberations that may have gone on behind the scenes between the individuals, there may be a deliberative process privilege, but when the agency officially responds to the comments and says, no, it doesn't mean this, it means that, and therefore we see no reason to change the rule, there's no longer a privilege as to what the agency's policy or interpretation is of that privilege, no matter whether I participated in it as a lawyer or I participated in it as a policymaker within the agency. There is no privilege as to that anymore. The agency's made a determination, right? And it's published its thoughts and its comments and its reasoning, right?
I agree with your statement, Judge. Our motion was predicated upon the witness designation, which states that Mr. Houston has proffered to talk about a change in policy implementation undertaken by the Sanctions Department.
And that could have developed after Mr. Houston left the agency, right? In which case, whatever opinion he formed may or may not be privileged. He may simply be comparing recent facts to facts that were there. We don't know until the question's asked. I guess is what I'm questioning, as opposed to saying there's just a blanket privilege that cloaks an individual simply because they're an attorney and simply because they worked at an agency.
I would submit, judges, that it appears very clear to us, based both from the designation itself and from the testimony transcript, or the transcript of intended testimony that's in Exhibit P76, that those subject matters go directly to privileged communications. They invoke, they implicate, they intrude upon the attorney-client and work product privileges that are applicable to strategic decision-making. They delve into the enforcement prerogatives and priorities and strategies of the OIG. The broader things that you're speaking to, Judge, about comments on proposed rules, responses to comments, once those rules are published and you deliver it, the process goes away, certainly I grant you that. But I don't think that's what we're talking about here.
But we'll go back to my question. If he was simply asked the fact, did you ever prosecute, did the Office of Inspector General ever prosecute an entity for X? There's nothing privileged about that. It's not asking, did you consider it? Did you talk about it? Did you think about doing it and not decide, and why?
Sure.
It's just a fact question. Did you ever do it? And if you did it, who did you do it to?
I agree, Judge.
There's nothing privileged about that.
Turning to the Exhibit P76, was that statement delivered to the committee members? The written statement?
I'm sorry, you repeat the question?
P76 is a copy of the statement that Mr. Houston prepared. Did he hand that copy to the committee members and to the other members in the audience? Mr.
I represented the court. I was present. I saw it. I heard it. Yes, he filed it with the committee clerk, Your Honor. You can go online and get a copy of the statement.
So it's filed as a record
Yes,
in the
yes.
committee proceeding?
As a public record?
Yes, Your Honor.
All right, and what efforts has the respondent taken to reassert their privilege and to protect their privilege? If you by accident mail a privileged document to the opposing counsel, you immediately must act to retrieve it. So I'm asking you've had several months now, what have you done to indicate that that was not and should never have been disclosed under attorney-client privilege?
We've not taken any efforts with the legislature to take any action.
Have you taken any efforts against Mr. Houston, either to district court to tell him he can't to get a restraint order preventing him from discussing this any further because he can't waive the attorney-client privilege? I'm asking what efforts. Y'all are asserting a blanket attorney-client privilege. And attorney-client privilege is in the rules very restricted to confidential communications that are not intended to ever be disclosed to third persons. So this was clearly disclosed to a lot of third persons, and it doesn't sound like that anything was done to protect or reassert that privilege.
That is correct, Judge. We have not taken any steps either with the legislature, with the state bar, or with any other authority to muzzle Mr. Houston. We have taken the steps of filing this motion in this proceeding because of the designation, the topics upon which Mr. Houston was anticipated to testify, which directly implicate strategy, tactics, decision-making by OIG decision-makers in the prosecution of these cases. Those are the appropriate venues, in our view, to take measures to prevent disclosure of confidential and privileged information. Can you bear with me one moment, please? I'd like to consult with this. Judge, thank you. I am advised that in response to one of your questions about contacting the state bar, that is an active discussion that is ongoing within OIG.
That's not privileged information you're disclosing now. No, I'm just teasing you. Go ahead. I'm sorry. No, I appreciate it. No, I appreciate it.
But that is it is something that's under consideration now, and it is my understanding that decision makers within OIG do wish to contact the state bar about this.
But as of this date, a couple months after the incident, after the speech was made or the statements were turned over, and it's now a matter in the public domain, there's been no effort to remove it from, to notify the committee that it needs to be marked confidential, that it was attorney-client privilege and was never waived. None of that has transpired.
That is correct, Judge.
All right. Judge Seitzman, correct me if I'm incorrect, but I believe our decision in this, we were conferring, as you were conferring, is that the motion to strike Mr. Houston as a witness is denied. That, however, does not remove your right to assert attorney-client privilege if the question calls for a communication that is properly confidential. Similarly, Mr. Canales, you can raise an issue of waiver if you believe that the question is dealing with confidential communications that were waived. And I suggest the parties come prepared with short trial briefs with the most current case law on that subject. If you're going to call Mr. Houston, I believe there's been some indication that there was an effort to have HHSC, Ms. Rutland, instruct them not to issue a subpoena. The subpoena needs to be issued. And again, you can raise your attorney-client privilege per question, and you can take the witness on voir dire if you need to clarify that the only reason he knows it is because of a communication that was never intended to be disclosed to third parties.
Plus, it's my understanding that it's a ministerial action in issuing the subpoena once it's been requested, and that the proper defense to that then is to file a motion to quash the subpoena. But that's my understanding of the process. Just going to more of a procedural matter, Mr. Canales, you indicated that Mr. Houston, you intend to be a rebuttal witness, it sounds like, with respect to Mr. Stick. So I take it we will not see Mr. Houston in your case in chief, that you're going to wait until...
Well, I take it they go first. They're going to call Mr. Stick for they have the burden. They're going to call Mr. Stick first, and I will hire Mr. Stick, and then whatever that's when I put my case on.
Okay, all right.
Now, one thing, forgive me, Judge, but I filed the motion for subpoena, requested subpoena, and I provided a copy of my request for subpoena to the opposing counsel. I think I don't know if I'm supposed to, but in the state court you don't do that in district. But I did it anyway. It's a right thing to do. So I did it. Now I have issued I have done this before in other cases, and I get my subpoenas granted right away, deposition notice and so forth. In this case, I have not received any word at all from the appeals division. Now, the court just said something about Judge Rutledge had been advised. I do not know whether they filed whether the AG's filed a notice with her, or they contacted her not to issue my subpoena or something. If they did, I submit that I'd like to know about that, because it kind of go against my grain, talking to the judge, issue, not to issue subpoena. If they file something, that's a different story, but I have not received, by the way, any type of a motion to quash or any motion with Judge Rutledge. So I'd like to inquire of the state, what do they do on this? Did they contact the judge not to do anything?
It did not come through me. I believe I saw something, Mr. Canales, you made a request, and I believe I saw something that indicated that there was going to be, I don't know if
Yeah,
there
I saw that. It was going to be, that's what I saw, but I haven't received anything.
Mr. Winter wanted to respond.
I'm sorry, Mr. Winters.
Thank you, Judge. We did file an opposition to the application for issuance of subpoena. We did copy Mr. Canales on it. He did get a copy of it. I've got a courtesy copy here if he wants to see it.
Yes, I do.
But we did file it. My understanding of your ruling is that the subpoena will issue.
Yes.
I mean, that typically, issuing the subpoena is a ministerial act. You touch all the bases, you submit your check for the witness fee, and it gets issued by the agency, and then the party can come and file a motion to quash or take such other action at SOAH with respect to the subpoena. I mean, that has been the process since, I've been here since 1999. I mean, there were some agencies that we did issue subpoenas for, like TCEQ. We did their subpoena issuance, mainly because sometimes money got put in the wrong funds over there, and then it was a legislative nightmare to get it back in the right place. So they delegated the subpoena issuance to us as opposed to the agency doing it. But anyway, you'll be able to reassert your objections to question each question. And we will, and if we forget, remind us, and we will instruct the witness to delay in answering the question until you've had time to interject.
Thank you. Appreciate that, Judge.
Okay. All right. I have next the motion to strike Dr. Orr and Dr. Evans, but since we've been talking about Mr. Stick, it might be beneficial to go to the motion in limine Mr. Stick and the corresponding motion to strike Mr. McClendon's
They all go together.
We understood from reading the materials that Mr. McClendon was simply going to rebut statements that Mr. Stick might make about something that was said at an informal
Yes, sir.
settlement conference. And I guess our question is, why is this even before us, since statements at an informal settlement conference would be protected?
That's exactly what I want to know. We filed a motion for preventing Mr. Stick from making any testimony, statements, whatever, regarding what was discussed at this informal conference. I believe I attached to my response the letter which says coming over and talk about the informal conference. I took the deposition of Mr. Stick, and he insists that he's going to be able to make some statements regarding what was said at the informal conference. We take the position it was not said, it did not happen. There were no admissions made, but Mr. Stick's position is it did. I filed my motion to eliminate, to prevent him from talking about anything that happened at the informal conference. If that occurs, I won't have to call, the McClendon issue's gone. That's pursuant to Rule 408, John.
Who's handling this issue?
I am, Judge.
Okay.
And I don't know that Mr. Stick is being solely called to testify about settlement conference, but both Judge Seitzman and I are fairly protective of anything that's disclosed in settlement discussions. It's identified as a settlement discussions or is intended to be a settlement discussion. So do you have some reason why comments made during a settlement conference would suddenly be open to being testified to during a hearing over an objection?
Judge, I think the characterization of this conference as a settlement conference is incorrect. It's our understanding it was not for the purposes of settlement discussions. And I'll point out the exhibit that's attached, Exhibit 1 on page 2 that's attached to Antoine's motion, states that you may submit any documentary evidence regarding whether this payment hold is warranted and any related issues. It's our understanding that this conference was basically a precursor to this hearing here today, and there were not discussions about, for example, exchanging money or dropping the proceeding. And I'd also point out, Your Honor, that there was typically, my practice, when we go to settlement conference, whether it's a mediation or an exchange of correspondence, we mark such documents, Texas Rule of Evidence 408, confidential. So we alert all parties that these discussions are protected under Rule 408. But here, this conference, we don't really take the position that it was for the purposes of settlement discussions, or rather, it was just as it's set out there on page 2.
Well, let me interrupt you and ask you, I'm reading here, if both an informal review and formal appeal hearing are chosen, the formal appeal hearing and all pertinent discovery, pre-hearing conferences, and all other issues and activities regarding the formal appeal hearing will be abated until all informal review discussions have ended without settlement or resolution of the issues. It sounds to me like the purpose of it is to see if you can reach a settlement. Just reading the letter.
Well, I see that, Judge, but I don't think that was the purpose of this conference. This conference was oftentimes within government agencies. You meet with the agent, you meet with the agency in question, and you have discussions about whether to move forward. And maybe this is a matter that we should address at the hearing itself, when we go to it.
Well, I can tell you that, many of the agencies that we deal with do have what we call ISCs, informal settlement conferences, which is really the initial thing after the allegations are made, where somebody comes in and then there's board members or whatever, and not the majority of the board, but designated board members that sit in there. It's not a formal mediation, but it is an opportunity for whoever is making the initial review to hear what the person has to say, and they have discussions, and then there's a proposed settlement that comes out of that that's either signed or not signed. And then if it doesn't resolve, then it goes on either to a formal mediation process and or to a hearing. I'm wondering how, to some degree, it doesn't really matter what you call it. The problem is what is its purpose? And it sounds like the purpose was to see if something could be resolved, and that sounds to me like settlement discussions, and settlement discussions are protected. I realize I'm putting you in a little bit of a difficult position because you were not part of that process.
Let me respond to that.
No, let me respond to it.
Just identify again yourself for the record.
I'm John Millock. I'm actually an attorney with the OIG, and I participated in numerous of these conferences. And while I know that many agencies have informal settlement conferences, that's not how these are couched. These are couched as an opportunity for each provider to come in and dispute the underlying allegations, to provide the OIG with either more evidence that supports their point, or to just basically come in and state their case. Generally, nothing gets resolved in these informal conferences. Generally, we either go to a hearing or we issue a notice of potential overpayment and go down that route and seek a settlement this way. Typically, if there is any settlement discussions, it's very, very, very rare. Most of the time, it comes in, the providers come in and try to state their cases to why we shouldn't keep going forth with the actions that we decide to take.
And so then do you not do any discovery when you get to the formal process because you say, we've got your statement as an admission on the record?
No, we do discovery, but generally no provider ever admits anything in these statements. It's very, very rare. We've had a few, but very rare.
Well, even your settlement agreements have it neither admit or deny in the language.
We say that just because we don't want any further action, because generally, sometimes the actions that we take could also subject to liability criminal actions with Medicaid programs.
I'm not berating you for doing that. I'm just noting that it looks to me like parties neither admit nor deny the factual allegations. They just admit that the allegations were made and they're attempting to resolve those allegations.
And in these specific type of conferences with regard to payment holds, generally, typically, we don't even have the full investigation in which we know what a potential settlement could be. So there was really no opportunity for us to have settlement, meaningful settlement discussions, because we typically don't have all the facts. We have enough facts to put them on payment hold that there's alleged program violations, but we typically don't have enough to make a legitimate settlement offer if there was one to be made from the other side.
Then I'm kind of, in looking at the letter that you issued, it appears that you are offering an opportunity to come and resolve the facts, and yet you're sitting here telling me that you didn't even have all the facts to resolve. I think that's somewhat
It's-
misleading
It's,
to the other side.
it's not, because we can take multiple actions against the provider, one of which is a payment hold, in which all we do is suspend payments while an investigation is pending to discover whether or not there is an overpayment.
I'm not talking about what actions you can take, I'm talking about your letter,
I-
what
I-
it
and
says
that-
you are
that's-
doing.
And one of the typical things that providers comment is that they can't have this payment hold action against them because they may go out of business. That is an opportunity for us to discuss whether or not we have enough evidence to, one, continue this payment hold only. Not whether or not we can continue the investigation. So I think it's a little bit different than settlement discussions. I mean, they come in and try to say, hey, take me off payment hold, here's some more information, here, I'm cooperating.
Where does it say this in your letter to the petitioner, that this is not a settlement and anything that they say can be disclosed? I'm looking at your letter, I just want you to point out to me where this is part of your investigation and they need to be put on notice that what they say can be used against them. Because it reads like it is a settlement conference. And it may, this is very tiny type, so it's very
Right.
possible it's in there, but I can't find it.
I mean, other than the fact that they're put on notice that the informal settlement, the informal resolution does not go their way, they have the right to appeal to a formal hearing. I think that pretty much puts them on notice because, they get an expedited administrative appeal. They get both.
That happens at every agency. If you don't settle, you then go on to a formal hearing process or to a mediation before you go to the, so you go outside the agency's parameters and you have a mediated settlement conference at SOAH. But you're not guaranteed that right. The agency can say, no, we don't want to mediate it, and it goes to a formal hearing, but.
Under our rules, we don't have any mediations. It's either an informal.
Right, I'm saying that the fact that you have an informal settlement conference, and then if that doesn't work, then you go to a formal hearing, and so that puts somebody on notice that it's not a settlement conference, that every agency that has an informal settlement conference eventually goes to a formal hearing if it doesn't get
But
resolved.
we've never characterized it as a settlement conference, as the court has said. We always have characterized it as an informal review. It's clearly stated in our rules it's an informal review. And, we make no assertions that it is a settlement conference.
Is Mr. Stick?
Stick.
Stick. How do you?
Stick, yes.
Stick, okay. Is Mr. Stick going to be called to testify for any other reason?
He is, Your Honor.
Talk to Judge Sykes.
But it involves his party.
Regarding the motion in limine, it's kind of odd that we don't have motion in limines in these proceedings, but here's, we understand what you're asking for. Since Mr. Stick is going to be coming to testify anyway, we're going to reserve ruling until he comes to testify. At that time, if he gets into the settlement conference and he wants to testify to it, raise your objection and we'll address it at that time. Given that, Mr. McClendon is not going to be struck if we allow Mr. Stick to testify based on your representation that it wasn't a settlement discussion. Then we're going to allow Mr. McClendon to testify as well. We will also allow any cross-exam regarding any statements Mr. Stick has made regarding policy on this issue during any conference. So,
Or anybody else from the agency. Not
so if
just
you're
Mr.
opening the door, it's going to open completely. I am not convinced that this isn't a settlement conference. They are given different names with different agencies. We hear over 80 some odd agencies. They all call them something different. But basically, the party arrives thinking that what they're saying is protected by the settlement language. And if you use the word settlement in the paragraph in a resolution, so you don't have to go to formal hearing, it sure sounds like a settlement conference to me. It is incumbent upon you, as being the primary person setting this up, to notify them that it is not confidential and that what they say may be used later against them. I don't see that in your letter. So at this point, we're going to hold off on ruling, see whether or not Mr. Stick is into this issue, if he's questioned about it. Advise Mr. Stick that if he's going to be testifying, because sometimes they're asked, are the walls gray, and they start talking about the outside room. So please advise him that he is not to discuss anything about that settlement conference until we've made a ruling.
And so, I guess in a way, we are granting the limity in the sense that before it's brought up, the parties need to approach the bench so that we can reconsider this, and if we need to also, if we're going to go into it, then or parse it more finely, we'll have that opportunity. So for the time being, the limity is granted. We're not excluding Mr. Stick, and we're not excluding that line of testimony altogether, but we want it brought up. So if you're going to cover everything else with Mr. Stick that you want to cover, and then we're going to get into that, then we can take that up and try and do it as a discrete portion. And if you want to make a record on it, you'll have an opportunity to make a record on it.
And I understand the sole reason for calling Mr. McClendon is to address comments made during the settlement conference. So if he's not going to,
If he
he'll
won't touch
withdraw.
something, we won't bring McClendon.
But judges,
That's why the sound you just heard was Mr. McClendon's sigh of relief.
Yeah. There is one additional procedural ground. We object to Mr. McClendon testifying, and Ms. Silhan is going to address that for the court.
Please bear with me. I've spent a few years briefing, but this is my first hearing. So, we've also moved to strike Mr. McClendon on the grounds that he wasn't disclosed or designated as a witness until May 15th. So 2 weeks after the discovery period in this case closed. We designated Mr. Stick as a witness on February 15th. Petitioners have filed 3 Rule 194.2 designations since that time, one of which cross-designated Mr. Stick, but none of which disclosed that Mr. McClendon would be coming in, or called in this case, to rebut Mr. Stick's testimony within a time period that would have allowed us any kind of discovery. So we're caught a little bit off guard. We do recall that when we timely designated 20 witnesses at the close of discovery, that caused an issue, and this body determined that because we knew of these witnesses' existence beforehand, that we should have designated them in a more timely manner. We identify the same issue here, and would ask that he be struck for that reason as well.
Let me ask, Mr. Canales, when was the first time that you knew that Mr. Stick was intending on testifying about what was said during what you're asserting were settlement conferences?
When I took his at the time, I'd taken his depositions when he announced it, then I had to go verify who else was there at that statement. And so her comments are correct. It was designated afterwards. But
When was he deposed?
For rebuttal.
When was he deposed? Mr. Stick?
I'll have to look.
Your Honor,
So, somebody close me there.
Mr. Carode, his deposition was taken on April 18th, and Mr. McClendon was not present, but his law partner, Mr. Watkins, was present at that deposition.
So after that date, I had to, Mr. Carroll was not, Mr. Watto was not present at the conference, the formal conference. The question is, Judge, I don't plan to call him as a direct witness. I plan to call him as a rebuttal. The question is, do I have to list every rebuttal? I told him exactly what the issue was. He's a rebuttal witness. And so my position is that he doesn't testify regarding what the court has already ruled on the issue of the office of compromise. I don't plan to call him. Don't plan to call him at all. He'd strictly be able to say, no, I was there, and that statement was not made. So I don't plan to call him for any other purpose.
If I may. As aside from the late notice, we would also note that Mr. Nazari was there. He's been designated before. We're wondering why he wouldn't be able to testify. And I'd also like to note that, again, Mr. Nazari was designated prior to the end of discovery, and of course is a crucial part of this case. Mr. McClendon is counsel of record in this case. It's rather extraordinary for him to be called as a witness in any case, but after the close of discovery, it's an entirely different matter.
And they chose not to take my client's deposition. Even though it was agreed to, they chose not to take my client's deposition. So,
At this point, we'll reserve ruling on that at the time, whether or not he's actually a rebuttal witness.
very well.
So the issues regarding Mr. Stick, whether or not he can testify to the settlement discussions, will be something we address at the hearing. If we allow him to do it, then we'll address the issue of whether or not you timely disclose Mr. McClendon as a witness.
I will tell you quite frankly that where I lean right now very strongly is, based on the language that's in the letter, is that it is a settlement conference. I don't care what you call it. A casual get-together. It's not the title of what it is. It's what it is. And so, I'm only one of two votes, but I'll just tell you that my vote right now is it looks and smells a lot like a settlement conference, and settlement conferences, things that are said there are confidential. And I can be persuaded the other way, but I'm just telling you where I'm leaning real, like in a hurricane, I'm leaning that far right now. So.
All right. Moving on to the motion to strike Dr. Orr and Dr. Evans, it appears that everyone has read order number 2, and the deadline to file objections to experts was way before this week. And so both those motions are denied.
And let me just add, in looking at that, we looked at the grounds for the objections, and it appears that the grounds for the objections were known to the parties even before they were designated as experts. So it's not like some new information came forward that the parties didn't have prior to that.
Just to make sure we're clear on that, I understand the court's ruling on the matter, but one of the chief grounds in our motion is, in the motion to strike Dr. Orr, is the testimony of Dr. Ornish, who is another expert that's retained by the petitioner in this case. That deposition was not taken until May 9th.
You can impeach him with it, you can go to his credibility with it, but the part of the grounds for your motion was known prior to it, and so there was no reason it couldn't be raised in time to meet the filing deadline. So, on everybody's part, both sides are.
Okay. Turning to the objections to the exhibits that were submitted by respondent petitioner's objections. We can't rule on the ones that we couldn't open, so.
But I have some questions. But may have some questions about them, nevertheless. But you want to just take them in order? Just start with R3 and work our way through? The agreed settlement order from 2007?
Your Honor, actually, I just remembered one thing that's an exhibit issue that, since we've been talking about attorney-client confidential communications and all, we noticed on P77, which is petitioner's exhibit number 77, it is a chart that compares the expert scores to Antoine dental scores. We noticed on there that it says attorney-client confidential communications, and we just wanted to alert that to the court's attention in case that's something that they need to snap back or anything like that, just to bring it to everyone's attention.
That's a computer. A computer puts that on everything.
Okay, just.
Yeah, that's fine. We appreciate that, and maybe what you might do is, for the record copy, is just provide a substitute.
Yes, I will.
That has that.
I'm too old for
Thank
tricks
you for drawing our
anymore.
attention to it.
Maybe I was 40.
Yeah, thank you. So again, just like any other additional information that we're going to need a substitute copy on, if you can just provide, again, we don't need it for for the judge's copy, but for the record copy, that would be very helpful. Okay, R3 was the agreed settlement order from 2007, and the objection
It's
was,
hearsay and relevance. Can somebody, I mean, hearsay I'm not too persuaded by, it's a settlement order.
This is
So
a-
what's the relevance?
Well, this is a reprimand that was passed by the dental board against Dr. Nazari back in, I'm pulling it up, so I can say it real quick, like back in 2009. Has nothing to do with this
It
case.
deals with the one patient, December 2004 and 2005.
It's-
And
Okay,
there's-
I'm asking them what the relevance
forgive me.
is.
especially where there's the statement that there's the facts, there's no,
Judge, the answer is because it's exactly the same kind of conduct that's at issue here, where they're doing inappropriate treatment.
Okay, you need to state your
you
name.
need to state your name for the record, so.
I would have thought after I said Moriarty, you wouldn't forget it, but
No, we don't forget, but the recorder does.
I'm sorry, I won't do that. I promise I won't do that again. The answer is it's relevant because it's the same kind of misconduct that we saw here. In that case, it was one patient. In this case, it's hundreds, if not thousands of patients. That conduct is directly relevant.
And may I point out, judges, under Texas Rule of Evidence 404B, it is admissible. Generally, character evidence is inadmissible, and I'll quote from the rule here. It may, however, be admissible for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. So we think it's relevant as it relates to his current pattern of practice of the misconduct in this proceeding. It's similar, and in many cases, the exact same misconduct that occurred that was the basis of his board action. So under 404B, it is admissible.
Even though it says that he neither admits nor denies the factual allegations in there. So, I mean, it's an agreed board order. In which case, the parties have resolved it without an admission that the facts alleged are true,
Well,
and that the misdeeds that are alleged are true. I say you may get something, but I'm not sure how much it's worth without an admission.
well, if it goes to the weight, Judge, that's one thing. If it goes to admissibility, I think under 404B.
That's what I'm saying. You may get something, but I'm not sure how much it's
Right.
how much it's worth.
Do you agree? The objection's overruled. Dr. Evans, February 21st, 2012 report, objection hearsay?
Yes, Ron, I don't have any objection to the CVs coming in of all these experts, so I think it helps all of us. But their actual report, they're going to be testifying live. I don't think we need to have the reports coming in either. I didn't offer mine, by the way. I didn't put down ordinances or ours. And I don't think they're entitled to have the reports either. Reports is hearsay. Now, they're going to be testifying live. So why do we need the reports where it's hearsay? I wasn't there when they prepared the report.
Because it might cut out 3 hours of direct exam by you adopt this report as your testimony.
And you can do it that, at this
If you want
point,
to do that too, that's
it's not going to be admitted, but if you have the witness on the stand, we'll allow them to adopt that as their testimony.
And not testifying about anything else?
At that point, you can cross-examine them.
Oh, I understand that, yeah.
They may do. I mean, they can do whatever they want, but it does. The expert
I know, but
report.
they don't plan to do that, John. They plan to do both things. They plan to offer the report and evidence, and then also ask them questions on their
If it's in evidence, we don't need a whole lot of testimony about it, Mr. Canal.
Well, I understand that, but the question is, if they're not going to ask any questions.
Well, they may or may not. I don't know what they're going to do. I'm not going to try their case for them, and I'm not going to let you try their case for them. Just like
But they
I'm not
should
going to
have
let.
both of them. They should
But I'm
have
not going to let them
Have
try
both.
your case for you. But having the expert reports in evidence can save a whole lot of time in terms of testimony. It also allows us to read some of the stuff. But, and if they contradict themselves, I'm sure you'll have an opportunity to ask them about it. And, it's in the report. And whether or not they ask them a question about it, if it's in their report, it's in evidence, you're free to ask them cross-examination questions.
I like leave of court to be
Okay.
able to add my reports, my
All right.
experts.
Again,
Mr. Hargrove, did you hear Mr. Canale's request?
I apologize, I did not.
I like to be able, I did not offer my reports because I feel that my experience has been they're not admissible because they're going to be testifying live. So I plan to call my experts, but I would like to be able to offer them, add to my list the expert report of Dr. Ornish and Dr. Moore.
Have you received those in discovery?
We have, Your Honor.
Do you have any objection to them doing that?
Why don't we just wait for the hearing and see how it goes at the hearing? I mean,
Well, here's the deal. If we're going to admit the reports, we're going to let all the experts to do it. Generally, we allow expert reports in to shorten the hearing. We read those reports before we come in. We don't want you to go through them again, bit by bit.
Generally, what we do is, especially in our more complicated cases, which tend to be our longer cases, but you take Public Utility Commission cases, you take TCQ permit cases, you take anything that's got a Texas Department of Insurance rate cases. One of two things happens. You pre-file your testimony, which usually includes all of your expert reports as appendices, or you pre-file your report with very cursory direct with respect to that report, because the report basically is the testimony. So the way we're used to working around here is you get the report, it helps us, it helps the other parties, it can focus the cross-examination, and it's not only time-saving, it's much more helpful because we will have read the information that the expert's fixing to talk about as opposed to sitting here hearing it for the first time cold. So,
And Judge, the only concern I would have is I don't want it to preclude the presentation of our evidence, because we really want you all to hear Professor Tadlock too.
and it doesn't, it just,
Sure.
but we have a basis of understanding what he's going to talk about or she's going to talk about before they start talking, and you don't have to be, you can get to the points that you really want to cover, as to pose, what is a tooth? We can read what a tooth is in the report, and you can get more focused in terms of your direct, if you wish.
That's fine.
So the leave is granted.
Do you have any objection to Ornish and
Or?
No, Judge.
Okay. You've got those already.
That's correct.
Will you
Go ahead.
Can you furnish those
Yes, I'll file
today or tomorrow?
By tomorrow. I'll file a supplemental list.
And if you've got them electronically,
Yes.
will you also send them electronically?
Yes, that's.
And I'll give you an email address to send those to. We'll get you to send those to.
We'll just file with the court with
a CD.
Oh, sure, I can.
Okay. I was going to also say, I can give you my legal assistant's email address, and you can email it.
We'll do it.
I'd rather carry it around on my laptop than.
We're from the same school.
Okay.
Very well. Thank you.
Next is the All Smiles Medicaid, and I'm using shorthand in here. All Smile Medicaid patient dental records. There's a hearsay and relevance objection. Briefly, can you explain what your objection is?
Well, can we back up a minute? And I want to be sure I understand what these documents were. This is from a dental clinic in Dallas, and these were the underlying records, and then Dr. Orr stored these records. Is that basically?
That's correct.
What it is? And are these? And so these have nothing to do with the patients from Antoine.
That's correct.
Okay. So is this being done more in terms of impeachment?
This is impeachment of Dr. Orr. That's what these records are going to be used for. These, and then R20, which is the All Smiles or HLD.
So they're not really being offered for the truth of the matter. They're being used for impeachment. Is that correct?
That is correct.
So a hearsay objection wouldn't necessarily apply if they're not coming in for the truth of the matter. In other words, they're being used to impeach Dr. Orr's methodology and scoring practice.
And to give you that's correct. And to give you some idea, the reason we put them on the exhibit list was not so much that we want to have these introduced into evidence. It's from the rules of we're not going to surprise you with all these records the day of trial. That this is what's coming on to cross-exam, and the interest being fairness to the parties, here's what's coming.
I will tell you that, and I think I speak for both of us, that we greatly appreciate the fact that both parties went beyond what the normal bounds would require in terms of putting in their impeachment evidence and also putting in their rebuttal witnesses, which you wouldn't, necessarily have to disclose. And so we appreciate that. I just wanted to address that because that's what I actually looked through those, and that's what it appeared to be to me. And so if it's being offered for impeachment purposes and not the truth of the matter, then it's not. Then there is no hearsay issue.
And they're not, and they don't come in evidence.
They come in to show that this is the way he scored those things, and to the extent that it's consistent or inconsistent with other practices, that's all it's done. It goes to his credibility, right? But it doesn't come in for the truth of the matter. Really don't care whether, I do care, but I don't care for purposes of this proceeding, whether an adolescent in Dallas that was treated at All Smiles scored 62 points or 2 points for purposes of knowing that that's what that adolescent had. It's just the mechanism, and is Dr. Orr consistent or inconsistent in the way that he scores. That basically. So it comes in for impeachment. It's a limited purpose impeachment only.
All of R19 are those patient file records.
Right.
And then they go to R20, and R20 is different. R20 is I'm taking this for impeachment purpose. R20 is the actual scoring sheet made by Dr. Orr.
Right.
So my objection goes to both of them.
Right, I understand, and what I was trying to clarify is, so both on 19 and 20, they're not coming in for the truth of the matter that this is what that adolescent had. They're coming in for purposes of showing this is what Dr. Orr had in front of him, and this is how Dr. Orr scored it.
Yes.
And so they're really, again, for impeachment purposes, and so they're not being admitted for the truth of the matter, so it's not hearsay, and they're only relevant is to whether Dr. Orr is consistent or inconsistent in the way that he does his analysis. And so, since they're coming in for impeachment purposes, then I would propose that we overrule the hearsay objections to both 19 and 20 and the relevance objections, but note that they'll be admitted for impeachment purposes only.
Yes. I understand the rule.
All right, the next one is the presentation. It was an objection to the presentation by Dr. Anderton and Dr. Orr. Have you been sued yet? From June 2013, which is after any of the events that are relevant before us. Or
Your Honor, it might be easier if I put some of these together by category.
That's fine.
R1 to R25 are all exhibits. So there's two that are relating to a course that's a lecture that has been given and will be given by Mr. Anderton, who is an attorney, and Dr. Orr, who we know. And then the three other exhibits are the what are specialties under the that are recognized by the American Board of the reason all of them go together, these are all impeachment documents of Dr. Orr. It's the same type of exhibits that were in the motion to strike Dr. Orr, that he claims to be the Texas Medicaid director, and he is not. And he claims to be an inclusion specialist. There is no specialty in inclusion. That's what these documents go to.
I'm sorry, I stepped in.
You said R1, and I think you mean R19?
R21 to
21, I may not have heard the 20.
R21 through R25.
Thank you.
And I would bet that we could get a stipulation that the American Dental Association doesn't have a recognized specialty of X, because it either does or it doesn't. So, I think we're fighting over kind of I understand what we're fighting over, and it's kind of a small issue, and it's kind of a side issue, but it goes to the credibility of Dr. Orr and what he says how he presents himself and what he claims special knowledge in. But I'm going to tell you that there are a lot of people before administrative law was a recognized category who call themselves administrative lawyers, because that's what they did. So we'll take it up, but it seems to me to be a credibility issue as opposed
we can try to work on a stipulation, but the question of whether the word specialist can be used for a specialty that does not exist, and the difference between being a claims administrator for a private contractor versus being a policymaker for the Texas Medicaid program are different. That's the issue that came up in Parliament that's going to come up again.
I understand, and I guess what I'm saying is I understand it. I hope we don't spend 3 hours on it.
I hope not.
It's not worthy of 3 hours.
It's only impeachment.
Yes, it is.
It doesn't come in, but they offered it as like a regular.
Right, and I understand that, and again, that, we kind of recognize some of that as we went through, so.
Can I break down the two things that you kind of group them all together? R20, R21, and R22 are those publications or articles that Dr. Orr and Mr. and they're both doctors, Dr. Anderton, a lawyer, have put out at I just don't see their relevancy at all.
If Dr. Orr did it, then
He did it. He did it.
Then they're entitled to ask him questions about it, and the fact is that they provided it to you, and so again, it's being offered for impeachment only, and as I understand it, 21, we've already done the other, so 21, 22 are for impeachment only, is that right?
And 23 to 25.
21 through 25, you said.
Well, I understand, but I break them down in a slightly different order.
Yeah.
Okay.
23
Through 25.
through 25 just have to do with what the recognized specialties are. And
And he can use that as impeachment. If he says he's something, they can impeach him with it.
right, but they're not. But I guess what I'm saying is I recognize them as being a little bit different because they're not something authored by Dr. Orr by himself or in conjunction with anything else. There are statements or policies or whatever by an independent third party that says these are what our
And actually, to
specialties are.
clarify, I don't want to misrepresent to the court, R21 and R22 are not authored by Dr. Orr. Those two are course descriptions from the UTSA or UT Health Science Center website that says, this is the course, it's going to be presented by Dr. Orr and Dr. Anderton. Here is a short bio for each. So I don't want to represent to the court that Dr. Orr wrote his own bio, but clearly if he signed off on that bio that says, so I don't want to say this is a publication.
And they can ask him about it.
I understand, and I hope we haven't spent as much time here on it as we're going to spend at the hearing. I hope we
No, I
spend
just
less at the
wanna be
hearing,
clear that
but I'm wondering on 23 through 25, if you just want us to take judicial notice or official notice of those documents. I mean, they're a little bit different. Those are the recognized specialties, and then they can ask him whatever questions, and Mr. Canales, you can do it, but just if you want, we can just take official notice that these are from these independent third-party specialty groups, these are the recognized specialties. That
would be fine with us, Your Honor.
Mr. Canales?
Well, I haven't really looked at it. I'll reserve on that one, Judge. I've got to look at what are they actually saying. I'll get a response real quick, like.
Tomorrow?
Oh, yeah.
Is that
This is, you're talking about number
23, 24, and 25.
I just got to be able to look at it. I want to be sure there's nothing there that will bite me. What's your greatest? Let's go sleep.
So I don't want to preempt.
Okay.
Better, okay.
All right. I'm going to retract my offer to officially notice him. Judge Egan?
When you get into impeachment, until we get through that process, if he admits that there is no specialty and that that's a misstatement or it never should have been in there, there's nothing further to do. And we don't need to have this stuff. If he denies it or he denies that he allowed that to go out, then we will certainly consider admitting it at that point for the purposes of impeachment.
So we reserved on 23 through 25. Okay.
20, we're at 26 26?
26 and 27, John, are kind of the same category.
Yes, that's what I was looking at.
They're,
These, if you,
So I'm sorry, the 26 is a document from the American Academy of Orthopedics or Orthodontics website that our expert is going to use as basically a teaching tool, talking about when different teeth come in at different times. That's the only purpose it's going to be used for. 27 is actually quite different. That's actually Dr. Kanan, who's one of the orthodontists for Antoine. That is a thesis that he wrote. Those are two different documents.
Is that going to be used for impeachment, Dr. Kanan, or?
I am not handling Dr. Kanan's cross-examination, but I'm sure it is.
and Dr. Kanan is,
I think he was actually on one.
yeah, he's identified.
Dr. Kanan did some of the patients in the case.
Right.
And this is his thesis when he got his master's. Did he write his thesis? You bet he did.
I mean, if he says no, we got a big.
Of course he did. The question again, Judge, is to be able to list them as like, be offering in evidence, and it's certainly not evidence at all.
Well, again, it's
impeachment.
It's an impeachment document. I think that's all it's being offered for, is impeachment.
Then let's see what the doctor has to say. If it needs to be admitted to establish an impeachment, we'll go ahead at that time.
That was 2006, so I'm sorry, 2012, R26, what document?
R26 is from the American Academy of Orthodontics. It's just a one-page flyer that shows, it's like a map of the teeth saying these are these teeth, this is the age they roughly come in. So it's more of a teaching tool that we'll use with our expert. It's demonstrative.
It's not admissible. If it's a teaching guide, whatever, it is.
Well, if it's just demonstrative, it's not being offered into evidence.
No, it'll be used by our experts.
But I'm saying.
No, it won't be offered into evidence.
Okay, so it's just demonstrative,
Yes.
so, okay.
I'm sorry, we were talking past each other.
28 is the printouts of pages and photographs from iSmile Specialties website. And there's a hearsay and relevance objection.
Yes.
Why is that relevant? Is iSmile is...
iSmilesSpecialist.com. That's the dental and orthodontic practice where Dr. Kanan works when he is not working at Antoine Dental Center. So there are certain pictures, there are certain descriptions of what is relevant or appropriate treatment for kids with various dental conditions on those websites. There are pictures of what would be considered overbite, overjet, those things. And these are documents and pictures that we're going to be using, again, in cross-examination of Dr. Kanan and possibly other witnesses about what is done in a private pay dental practice versus what is done when Medicaid is paying for dental treatment, and how those dental conditions are described and scored.
Are you contending that Dr. Kanan wrote what's on the website?
That may come up, and I don't know. But
Okay. All right, now, so it's just impeachment only? On Dr. Kanan?
Yes, Your Honor. Like I said, the purpose of these exhibits, it may seem voluminous, but we don't play trial by surprise, and we want to show these.
I understand. I'm just trying to make sure when I wrote my note down in my notebook, I got it exactly right. I mean, so if it's impeachment only, there won't be any hearsay issue. It may or may not be relevant. We'll just have to see what it is, yeah. 30?
All right, at 30 through 40, all have the same objection, the learned treatise objection, and it looks like these are periodicals and...
Are these things that your experts have relied upon, either in whole or in part, in forming their opinions?
Some of them are like the textbook, the Profit textbook. Other ones are getting into the definition of ectopic eruption and of the other dental conditions. So they'll be coming in through through our expert witnesses.
Well, I guess, let me tell you, so let me be real clear about my question. In other words, a lot of times, documents will be introduced to show the basis, either in whole or in part, for the expert forming the opinion that the expert is testifying about or is written about in their report. And so those documents aren't coming in for the truth of the matter asserted in the document. They're coming in to show this is what the expert relied upon, and it goes to the credibility and the weight to be given to the expert. So, you know, if you're relying on a medical judgment based on what's in, you know, Mother Goose magazine versus, you know, the American Medical Association journal, there's some weighing that may go on there. And that's why I'm asking if so, and so maybe, and I got from you that maybe not all of these are, but I'm not sure what your action, I'm not totally sure what your answer is. So if these are being admitted for the purpose of showing that this is what your expert relied upon in forming their definitions and their understandings and in doing their analysis and their scoring, that's one thing. And so even if it's hearsay, it doesn't matter because
703.
because a expert can rely in whole or in part upon hearsay. But if you're offering it for the truth of the matter, then that puts us in a different category. So I guess what I'm asking is are these articles simply showing the basis in whole or in part upon which your various experts relied in terms of forming their opinion of whatever opinions they came up with?
I would say, if I understand the question correctly, they would either come in as, like you said, 703 hearsay that they rely upon as the basis of their opinions that they will provide. And then also, I would need to look at each one of these, but some of these may also qualify as learned treatise 803.
Well, if it's a learned treatise, then I get into the problem of learned treatises aren't admitted, portions are read into the record.
What might be easier, Your Honor, is we may be able to slim down this list between now and next week.
That would be beneficial.
And I think that may short-circuit some of this discussion.
And you might, I don't know, but if Mr. Canales is receptive and you want to discuss with, you know, I mean, his experts may agree that, or may have used some of the same things in forming their opinion, or would agree that that is, you know, a good document to form an opinion on, or whatever, and y'all get that worked out, that's fine.
All these are learned treaties. That's what it is. They just went to the books, copied the books, and one offered in evidence. That he cannot do. That's what the rule was.
Typically in cases before us, because we don't want them to read, you know, a 10-page document into evidence, we allow them to submit the report instead, but not this many. So we'd like you to pare it down to what is essential, exchange it with Mr. Canales. Sure. Mr. Canales, you do the same thing, and if y'all can, you know, refine it down to something that's essential so that what we're looking at is something that's truly helpful to us and that both parties recognize as a learned treatise.
And if you're not submitting it for that purpose, just to give us the underlying documents that your expert relied upon, then you don't have to pare anything down.
Right.
And you don't even have to get Mr. Canales to agree to it. Because it's what your experts relied upon. And then they can say why they relied upon it or whatever.
Yes, sir.
All right, the amounts paid for 1999 through 2003, it appears to be a summary of what's paid under the Medicaid system.
I think this is the overall.
That's what I'm talking about, the complete summary.
Yeah, this is what they paid, I think, everybody in the state of Texas. This exhibit number one again, number?
41.
41.
Oh, 41, let me go back to 41.
1999 to 2013.
I think this right here, pull it out.
Well, before we go to your objection, what was the purpose in offering this document, I guess is the first thing.
Oh, yeah, this is for...
I believe this is just testimony, just to give overview of the Medicaid program, and just this is to the extent this is public information of the growth of the Medicaid program over the years. I don't remember exactly where there are various charts that we've pulled, and this is one of them. I don't.
This is a one-page document from my recollection of looking at it.
Yes, ma'am.
And is there any question that that's an accurate reflection of what is the overall totals that have been
Well,
paid?
they've attached an affidavit to it, so I'm more than sure that's correct. The question is, what does that have to do with from fiscal year 1999, the monthly averages, annual surveys? What does that have to do with our case? I submit it's a relevancy issue. I mean, there's only one reason to offer this, is to be able to prejudice or inflame the minds of the trier of fact, to be able to say, oh my God, there's a lot of money in there.
We keep the jury in the other room,
I
so it's
understand
okay.
it, but to be able to influence you, I mean, how much money was spent and so forth. I submit to you that this particular document has no relevancy at all. Was there any overpayment here?
I'm inclined to think it may just go to be whatever weight should be given, or maybe none, but I don't know that it affects the admissibility of the
I'm
document.
fine with admitting it. I don't know that it's going to do more than the fact that it increased over years, that, unless there's some compelling reason to show me that your client had an impact on that was improper, it's not going to do any more than give me some background on the Medicaid system in Texas.
Yeah, I don't know that it will be finding a fact, but it's admissible, its weight is questionable.
Very well.
There's a demonstrative chart for R42, the permanent tooth development, and unless there's a real reason, we're going to want a chart that shows where permanent teeth come in. I'd like the parties to get together and agree on a chart that shows where the teeth placement is and something.
Yeah, I mean, I guess we got
It's from,
R26 and R42, right?
And actually more than that, R42 and then up to R46, those
Yes.
are all various demonstratives as well. Some of them are video, some of them are a chart, and so it may just be a matter of, we can pare down that list. We can pare it down with our expert, and then also pare it down with Mr. Canales and see what we would like to use.
Yeah, I mean, and it would also be helpful, I mean, to the extent that we get to talking about a certain tooth or a certain location or those kinds of things, to have that up there and to have a common exhibit that all experts can refer to, and if they need to mark on it or whatever, or we can make multiple copies, so that it's much easier on the record to go back if everybody's referring to the same exhibit. And not saying, well, if you open your mouth and you count over 3 teeth, so we have I mean, we may want to convert it from a demonstrative exhibit only to an agreed exhibit.
So you're going to let me know, that's exhibit R42 to R46, they're going to
Yeah,
let me know.
and also look at the same thing on 26.
Yes, Your Honor.
And if your client has one that he prefers, submit it to them and see if they can agree. I would keep it as simple as possible so that what we're looking for is the placement of where the teeth are in the mouth, so that when we're talking about it, y'all can point out what the number, I know they categorize them by certain numbers.
We tried a construction case together for 8 weeks, and I mean, when we were talking about a bolt at a certain location, it was very helpful to have a diagram, and everybody could look at it and know exactly where in this huge building we were talking about and why that bolt was significant, so.
Are there any other,
Yes.
Yes.
I'm going to talk about that, but any more exhibits that we haven't addressed, or have we taken care of all the exhibits?
Well,
Other than the
kinda
3 that we
halfway.
can't
That's
look.
why, it's the 2 of those, the ones we can't look at, it's 6, it's R6 and R10. And those I'll refer to, I think we're all going to refer to them, attachment A. Is the attachment A one report made by Dr. Tadlock, attachment A report made by Dr. Evans? I believe that 6 is the attachment A by Evans, and 10 is the attachment of Tadlock.
Right.
And this is the worksheet that they use to be able to input into their extrapolation model. And so my objection to both of them are going to be identical. That these are done for purposes of litigation. These are the notes of somebody else. It might contain some documents, some notes by that perhaps each doctor dictated somebody else, but it's not their report. So anyway, so until we get them, I'd like to be able to reserve I want to be sure that I don't waive my objection to
But
6.
those are pending, so we
I
can...
can't
actually-
rule on them till I can open them up, so.
Very well,
okay.
very well.
Those are being reserved till we can actually see them. So, any other objections on evidence or exhibits that we haven't addressed yet?
I think we've covered it all, Judge.
Okay. We took a look at, we've been trying to read everything as it comes in, and the motion to respondent's memorandum of law raised an issue that I did not see in the complaint. And just to put everybody on notice, that complaint is what we limit the testimony and what we're discussing to what's been filed in pleading. And the question I have, I did not see in the complaint any reference to parents, an allegation, a complaint against petitioner for having parents pay for treatment. And I literally went through every allegation and broke it down. And it's past the time to plead, so I just want to put you on notice. If it's not pled, we're not going to allow you to put on evidence regarding it.
Judge, I'll have to check, and I'm not sure right now, but I believe that's a program violation, and I think program violations have been alleged in the complaint. There are many different types of program violations.
Well, the way I read the complaint is usually they said specifically, and then they gave specific examples. If you can tie it up at the time, I just wanted to put you on notice so you weren't caught off guard. If I can't see it in the complaint and don't think it's reasonably a logical,
And it was paragraph 8.03 of your overview.
Okay.
Specifically.
We'll look into that, and we'll see. We'll be prepared to address that if necessary in the hearing.
and I believe that was the only one we couldn't find. And you're welcome to turn in a memorandum.
Yes.
Is just merely an overview as far as we're concerned, but it does give us an idea of what your position is.
Yeah, and then where I find it's different, it's just going to be a short memorandum. Yes, I'll follow that.
Okay, and similarly, if the law isn't cited in the complaint, any reference to it in any memorandum will not be seriously considered because the complaint identifies the laws that are applicable, the rules and laws that are applicable to this proceeding, and is what the petitioner was put on notice of. Everybody understand?
Yes, Judge.
Okay. Let me make sure we've covered everything before we let you all go.
No, we're not letting them go.
No, we're not going to let you go because we want to discuss the witness list.
Okay, well, maybe before that, Judge, I was not present at the last pre-conference hearing, but it's my understanding that you all wanted some chart related to...
Yeah, well, Ms. Pettigrew, and remind me, Mr. Canales, what was that called? That big
Tool.
spreadsheet? The tool.
The tool.
So, what we had contemplated was, much like you would use in a contracts case or that we've used in nursing home violation cases, coming up with a violation log that would have a corresponding statute or regulatory citation, and then the initials or the references to the various individuals that are being used to support that alleged violation, and then whoever the witnesses are that we're going to address that. But what we understood was basically all of that information was available in the tool, and so what we were interested in was, and it doesn't have to be done beforehand, but it will help us in writing afterwards, and it can be submitted as part of the written closing briefs or whatever, is the tool modified to give us that kind of information, but also in a format where we can manipulate it, so that if you decide to sequence it one way and we would like to resequence it in another way, we would be able to do that.
Yeah.
Yes.
This is a stab at, I think, what you all have requested, and it's just a first draft. And is this something along the lines of what you all had in mind?
Ms. Pettigrew actually had something that was extremely detailed, and she thought they could add the extra categories. I have it upstairs, but I don't have it.
I believe the tool is something else. The tool has to do, and again, maybe someone from OIG needs to weigh in on this. The tool has to do with, has a great deal more information.
We weren't asking-
Overpayments and everything else. I think what we're trying to do is pare it down to patient, law, program violation, who are we getting that information?
We weren't necessarily interested in the whole tool, but what we were understanding is that the tool could be pared down into an Excel spreadsheet, or whatever, that give us, and we were interested in having in some kind of electric format that we could manipulate as well, so that if you decided to do it by category, and then we would decide we wanted to redo it by violation code or something, we could manipulate it.
I'm being advised that the extrapolation from the tool would end up looking something like Exhibit A, as far as the information that's in there. Or, Attachment A. And I don't know if that's...
Attachment A to what?
The Attachment A that is mysteriously behind a password protection, but that you had seen at the last hearing.
When we break to go do the witness list, which we're going to do off the record, I'll go upstairs and there were two versions that Ms. Pettigrew gave us, and I can't remember what the difference was, but we can take a look at it and see if we can clarify it.
This is relatively close. I mean, this is within the ballpark of what we were talking about.
Any feedback? I mean, that's what I had in mind. The spreadsheet of it might be unwieldy.
Again, this is something we ask the parties to do at the back end when we already know what evidence, so you can draw specifically to the transcript and specifically to the exhibits. Something I just thought of when you said that, and it's gone out of my brain.
I have some unfinished business.
It'll come back to me in a minute, but you don't have to do it before the hearing. It's to be done after the hearing, and it's a tool for us to use, and both parties, it's one tool. If you disagree about what exhibits show, you put down what exhibit petitioner believes are applicable, and respondent puts what they believe is applicable.
It's a shortcut for us, and I think we really would prefer it in an electronic format as opposed to a paper format, just because we can manipulate it if we need to.
One of the things we understood from Ms. Pettigrew was that one patient could put out multiple violations. So it could be that each, when they were doing the coding, that they improperly coded for several things or improperly coded too many things into one. And so it would be a separate, this tool had it separated from what I understand. So it may need to be modified. It would probably be easier. I don't know how we're going to want to do it. So that's what we want to do.
Yeah, we don't know how we're going to do it yet. We don't know how we're going to split the issues or whatever. And so, but this was not, we weren't wanting it at the front end. We were wanting it at the back end after, everything was in and done. And it's more of a closing brief type of.
May I just quickly to clarify, would you like this in Excel format so that it sounds like you want to be able to sort?
Yes.
Okay.
You
like to be able to sort. And then if you're going to be sorting by violation, then we'll need to separate it. Since one patient can represent multiple violations, we'll have to include multiple, each patient might have several columns.
Either that or you can code the violation so that a 1 code is this violation, a 2 code is that violation.
Okay, we'll just make sure that
And we
you
can sort by 1s or 2s or whatever.
Or there's no violation.
Thank you.
Or there's no violation. Well, we'll figure that out, but I don't think they're going to code it as a 0.
All right.
Thank you.
You had one more thing to take
Yes,
up?
sir, I've been going through my checklist. I had a couple of motions pending. I cannot recall whether you had ruled on it or not.
What?
One of them was, I call this my petition motion for partial summary disposition.
We did.
And you overruled it, I take it, because I'm here today. And the second one is called there was the petitioner's motion for partial summary disposition. And that's my collateral estoppel.
We did.
We did. There's an order on
And
that.
there's a citation actually in the order to the opinion by Justice Doggett that I was referring to. Which I didn't realize at the time until I went back and looked it up, that Ms. Pettigrew was counsel for
So
the
I
state
take
on.
it it's some of the followers somewhere.
It would be, I could probably tell you.
Like order 7 or 8.
Okay, all right.
Here again.
Now I guess the issue now, the witness list.
So is there anything else that the parties want to take up while we're on the record? Do we have thing?
I think it's order number 5.
If I could just get some clarification so we can present the evidence well to the judges. So there basically will be no closing summation, but it'll be summation by written briefs, right?
We would prefer it to give you an opportunity to go back and marshal your evidence. And generally, the way I prefer it, and I think, I don't know whether Judge Eakin prefers it this way or not. She'll tell me if she doesn't. I actually prefer if both parties file their initial briefs on the same date and then both parties file their reply briefs on the same date rather than staggering it out over 4 different dates. So you make your arguments, you get to see what the other party said, and everybody files their replies.
The only addition is I want the parties to come up with an outline so that when we're looking at the first allegation, everybody's on the same page addressing it, so we know where to look in the other person's brief. So, if y'all can get together and come up with an outline that you both are comfortable using, that would be great. Otherwise, we'll come up with it. But it makes it easier for us. That way we can look at the same section in each paper and know that that's the argument on this issue.
The other thing that, and I'm not going to require you to do it, but to the extent that you can, it makes life easier, I think, for everybody. And that is to the extent that you can stipulate to certain facts along the lines, even if it's just the procedural history or those kinds of things, so that, it's done. We don't need to read about it. You don't need to write about it. Everybody's agreed on it, and pretty much if we'll put it in the way the parties agree to it. If we have a problem with it, we would let you know. In terms of the presentation of the evidence, since the resumes are going to be in as exhibits, I don't really need an expert to read through their entire. I can read the resume, but I understand that there are things within the resume that you'd like to highlight, and so that's fine. We haven't become federal judges yet, so we won't preclude you from doing that. But we don't need the witness to go through the entirety of their resume for us. And again, to the extent that items are in their reports, and you want to focus on the meatier portions and the issues that are truly in contention, that will be more helpful to us than going through things that are not in contention.
I was in front of a federal judge out of this state whose pre-trial order required stuff you agreed to, facts you agreed to, and then the facts you don't agree to. We had a huge list of facts we could agree to. We fought for days on the facts were that we disagreed to, and I never had that happen before.
Yeah, I had a federal judge tell me what facts I did agree to. So.
Anything else?
Since we'll have a transcript, to the extent in your briefing that you can cite, and we understand that you don't want and you're not going to want to pay for same-day transcripts. So we'll figure out a briefing schedule that'll work for everybody that includes time for you to get back transcripts and read them. And I mean, you don't have to footnote everything, but again, to key portions of testimony or numbers or, key ingredients, the fact that if you can cite back to the record, it makes it very helpful for us to go back and look at it as we're writing too. That's it.
All right. Anything further from anyone else that needs to be on the record? Then we'll go ahead and adjourn this pre-hearing conference, and if the parties can remain, we'll try to walk through some of the witness lists. And I'm going to run.
And it's 3:26.